Welcome back to For the Defense. My name is David Oscar Markus, and we have a real treat for you with this bonus episode. This week, we have Judge Kevin Newsom from the 11th Circuit visiting with us, and I think you're going to really love Judge Newsom. He's funny, he's smart, he's accessible. We talk all things from legal writing to him writing concurrences to his own opinions to what's going on the 11th Circuit and funny stories about his colleagues like Judge Pryor. And I think you'll hear he's just a regular good guy. And that's one of the reasons we're doing these podcasts with the judges, because I think it's important to hear who these people are. And you get to know Judge Newsom and hear what a wonderful good guy he is. So I hope you enjoy this episode as much as I do. Judge Kevin Newsom in For the Defense. Next. So I'm really excited this morning. We have Judge Kevin Newsom from the 11th Circuit on the podcast. And let me just tell you a little about the judge who really needs no introduction. He's from Birmingham, Alabama. He finished first in his class from Stanford, went to Harvard Law School, and was in a special class, the class of 97, which I was also in. And look, the judge has become an appellate judge, and I am a street lawyer. So it shows the difference with what can happen from our Harvard class. But before I continue with the introduction, did we have any classes together? I don't remember.
Yeah, I think so. Somehow I definitely I sort of followed your career, and this whole simple country lawyer thing is only going to take you so far. But yeah, so I've kind of followed your career and knew, he was in my class, and I don't remember sort of if we were in the same section or if we might have had an advanced criminal procedure class together or something, but I definitely sort of knew who you were.
So I transferred after my first year. I went to the University of Miami my first year of law school and then transferred to Harvard for my second year. I remember showing up second year with no classes a few days before class started, and they put me, my very first class was tax with 100 students. I had no interest in tax, but that was the only opening. And I show up, I hadn't even gotten a book yet or anything because I didn't know what to do. And the professor, the very first morning of my very first class, calls on me as the first person called on and told me to recite some case. And I just pretended like I wasn't there. So I didn't say a word. I just stared straight ahead because I didn't know what to do.
That is incredible. What a great story.
Yeah. So you go on, Judge, and you clerk both on the 9th Circuit and in the Supreme Court for Justice Souter. Tell us a little about the clerking on the Supreme Court, because it's just, to me, the coolest thing you could do.
Yeah, it was so great. So I clerked for two very different judges, right? I sort of joke about this. It's like the well-worn O'Scanlan to Souter path. Scanlon, at least by reputation, is a sort of a quite conservative judge, if you will, sort of a Reagan conservative, and Souter, a Republican appointee, sort of turned out not to be quite as conservative as some had predicted, but I just adore both of them, and learned so much from both, and have really carried a lot from both of those experiences into my own. Sort of the way I sort of approach cases and manage chambers. But the clerkship of Justice Souter in particular was just a magical year. I tell people, I remember when I was interviewing for the job, my mentor at Covington, this just prince of a guy named Bob Long. I was a young lawyer at Covington between my two clerkships. And Bob, who had clerked at the court, he said to me, maybe right before I went over to interview, he said, "Now, Kevin, here's the deal. If you don't get this, don't feel too bad about yourself. And if you get it, don't feel too good about yourself."
That's good.
Which is just such good advice because, for each of the, say, 35 or 36 spots at the Supreme Court each year, there are hundreds of people who would be great. And I don't know how in the world it is that, Justice Souter decided I was worth the risk. But it was a really sort of a magical year, and he was just, so smart. My co-clerks and I used to joke that I don't really think he needed us around. I think he genuinely could have done the job by himself. And we were just sort of playmates. He liked having us around for maybe for comic relief. And and, sort of a little assistance here and there, but he was just genuinely such a powerful intellect. But also just such a sort of a decent guy.
Any good suitor stories? I mean,
Oh my gosh. He one of the best things about Justice Souter, I guess I'll tell you two. So number one, he loves telling stories on himself. I'll tell you a story that he told us on himself. That'll be number two. Number one, this is a bizarre story about me getting the clerkship. So I interviewed with Justice Souter I'm trying to remember this now, the spring, I'm going to date myself here, but the spring of 1999. He typically hired sort of late in the cycle. So he was interviewing kids in the spring of 1999 for a spot to begin that summer or fall. So like sort of 6 months later. And I went in, interviewed, thought it went well enough. And probably, let's say that's February or something, about 2 months later, I got a very nice handwritten note in his sort of Declaration of Independence looking writing, sort of, quill pen writing, that I interpreted as effectively a very sort of polite thanks but no thanks note. It was, basically saying like, I can't offer you a position in the, sort of in the upcoming term. And I just thought, well, too bad. That was worth a shot. I'll sort of settle back into my practice at Covington, which I loved. And it so happened that I was working with each of two lawyers, both of whom had a case in the Supreme Court, sort of beginning that fall. And, one of the cases was this really boring ERISA coverage case or something. And the other was a case for ExxonMobil that was effectively a breach of contract action against the government that had come up from the Court of Federal Claims in the Federal Circuit. Okay. Well, so the ERISA case gets decided, sort of flash forward, gets decided in like April of 2000. In mid to late June of 2000, that Exxon case still has not been decided, which is just sort of inexplicable because, they're saving up for all these really sexy front page of the New York Times kinds of cases. And this breach of contract case still hasn't been decided. So this sounds like a horse and buggy kind of story. I was sort of slow one morning at Covington and I thought, you know what I'm going to do? I'm going to get in a cab and I'm going to go up to the Supreme Court, get in the line and just wander in and see if by chance they announce that Exxon case this morning. So I go in, lo and behold, Chief Justice Rehnquist says Justice Breyer has the opinion for the court in Exxon versus the United States. Breyer says Exxon wins. That was our client. Wow. So, I scurry back to the office. This is before SCOTUS blog. Now I'm really dating myself. Yeah. And so when I get back, I've got about 10 voicemail messages, from various partners saying, I heard that, hear that we won the Exxon case. Can you please get me a copy of the opinion, whatever. And the very last of these voicemail messages is from my secretary, whose name was Barbara. And she said, Kevin, this is Barbara. A gentleman named Souter from the Supreme Court called and asked if you would call him back.
Oh my God.
And so I didn't know much. I'm some 25-year-old nobody or whatever. And I didn't know much about the Supreme Court, but I did know, one, that the clerk of the court, like the chief administrative officer of the court's name was William Souter.
Right.
S-U-T-E-R. And I also knew that the court had a practice, which it still does, I think, of calling the lead lawyer on either side of the case, literally as the opinion is being announced to say you won or you lost, here's the vote, whatever. And so I wasn't quite sure why William Souter made these calls himself. It just seemed like surely he had people who had people who had people who made these calls. And I couldn't figure out why he was calling me because I was like the fourth guy down on the signature block. But I figured, I guess he called Ed and Ed wasn't home. So he called Steve and Steve wasn't home, called Mary wasn't home. So he finally called Kevin. So I just had this number and I dialed it up and some voice says hello. And I said, hi, this is Kevin Newsom calling from Covington and Burling. And he says, oh, hi, Kevin, congratulations on winning the Exxon case this morning. And I thought, oh, thank you. And he said, but I'll tell you what, this case has really been a tricky issue for me. And I was like, really? How is that so? And he said, well, this is a phone call that I've been needing to make for more than a year now. And I was like, I'm sorry, what are we talking about? And he said, well, I mean, like, if you still want the clerkship, it's yours.
Oh, what is
and I was like, Dear God, I'm not talking to William Souter. I'm talking to David Souter.
Unbelievable.
It wasn't until that minute that I realized who I was talking to. And sort of the backstory basically is, so his note to me was not a not ever, it was a not now. And he, in his own mind, had just decided, I'm not going to hire him for 99. I think I'm going to hire him for 2000. But instead of going ahead and hiring me then, he was going to just kind of like hold the space and then hire me when he hired the others. And so, but by that time, the cert petition in the Exxon case had come in with my name on it. And he was thinking like, oh, shoot, like maybe I shouldn't hire him now or yet, and so, would that create recusal issues or whatever? And so he said that he waited and waited and waited and waited for the case to get finalized. And eventually, when at the, one of the last conferences of the term, and Rehnquist says, Steve to Breyer, like, Steve, do you have Exxon ready? And Breyer says, yeah, I've got it ready. Souter says he sort of raises his hand and says, okay, I have a question I need to ask the conference. Like, I had it in mind to hire this kid. His name was on the cert petition and then the merits briefs in Exxon. Now that we've decided the case, can I go ahead and call in and hire him? Or do you think I ought to wait for the petition for rehearing to come in and be denied and all this stuff? And he said that essentially, sort of by acclamation, everybody around the table said, no, go ahead and hire him.
Story. It's like a sitcom when you took the phone call, like a Friends episode where you think it's somebody else.
It's crazy, crazy, crazy. So, all right. So that one went on for a while. Here's an even better Souter story about Souter that he told on himself, and that I've told many people. So when he was a justice on the New Hampshire Supreme Court, I think that might be a 5-justice court. It's a smaller court in any event, sort of a more intimate, cozy atmosphere than the U.S. Supreme Court. And he said that when they celebrated birthdays in the building, sort of communally, and so there was a clerk in another chambers who was having a birthday celebration. Justice Souter said he got sort of hung up on a phone call with a buddy of his up in like at the New Hampshire State Historical Society or something. And so he got down a little late to the birthday party. And he said the honoree came up to him and gave him a piece of cake and said, Justice Souter, I'm sorry that you weren't here for the cake cutting. If you can believe it, my co-clerks got me a cake with a picture of Garfield on it. And Justice Souter said he took the cake and, ate a few bites and wandered back upstairs and thought, you know what? I'm going to ring up my friend who I was just on the phone with and sort of tell him about this episode. So he calls his friend and he says, John or whatever, you and I were just sort of bemoaning and lamenting the lack of civics education among, today's youth. And in fact, that's not true. I just came from a birthday party in which the honoree described to me the cake, which had a portrait of Garfield on it. And he says, and you can sort of hear him saying this in his New England accent, he says, and then there was this weird, awkward pause. He says, and then he explained to me, it was that damned orange cat.
It's great.
And so when I tell that story, the thing that I think is funniest about it and really tells you most about Justice Souter is that there's only one person in the history of humanity who has ever thought that having a portrait of Garfield on a birthday cake is not like outside the realm of possibility, like maybe a little weird, but not outside the realm of possibility. I think in Souter's mind, he was thinking like, I'm really sort of more a Lincoln man myself, but if you float your boat, that's fine.
It's great.
So,
I love it. Such a good story.
He's just one of a kind, absolutely one of a kind. And I think he sort of knows that he is idiosyncratic in such an adorable way, and he kind of leans into it. Right. So I don't know. He's just so smart, so decent, and so kind of quirky. I just say he's like a sort of an 18th century lawyer stuck in the 20th or 21st century.
Love it.
So, but in any event, I've taken too much of your time with this.
Oh, I love these. This is what the podcast is about. These stories. Are you kidding me? Did you ever get to play hoops on the highest court on the land?
Oh yeah, we played every Tuesday and Thursday afternoon. And it's interesting. I have you seen it?
I haven't. I really want to see it. I need to see that.
Right. So here's what you need to know, that it will forever change the trajectory of your jump shot, because the ceiling is probably only about, I don't know, 16, 18 feet high.
You have
and
to
so
line
you shoot a lot of line drives. So it really sort of changes the nature of the game. And if people ask me, hey, like, were you a pretty good player? I always tell them, like, for the Supreme Court Clerk Basketball League, I was okay. Like, that's a pretty low bar, but I was okay. I might have been sort of middle of the pack for the Supreme Court Clerk Basketball League. There were a couple of guys my year, Mark Stancil in particular, who was like a baller, like really, really, really good. And so, and then Nick Braven, who was Jess Braven, who writes for the Wall Street Journal. Jess's brother, Nick, was a Ginsburg clerk. Stancil was a Rankers clerk. Those guys were really, really, really good. And so if you wanted to keep the floor, we basically, played to 7-by-1s and the winning team kept the floor. So if you wanted to keep the floor, you really wanted either Stancil or Braven on your team. And the rest of us just kind of ran around and, made noise.
That's great. And so after you clerk, of course, you're in private practice, but, I see you also, of course, were in the SG's office in Alabama, and of course, with William Pryor.
Yeah.
And you can't get away from the guy. He's now your chief judge.
Yeah.
You've been sort of with Judge Pryor for a long time now.
Yeah, it's interesting. This is like a little piece of professional advice that I try to give young lawyers, and that I hope, either listeners or people in your class will take to heart. So when I was finishing up the clerkship with Souter, now Sixth Circuit Judge Jeff Sutton, who was then at Jones Day in Columbus, called the sort of all of the outgoing Supreme Court clerks, not just me, but all of us, to, try to recruit us to Jones Day. And, I had a very friendly conversation with him, and I said, I think I've decided to go back to Covington, where I was between the two clerkships, and I really like the people there. And of course, he was as gracious as he can be. If you've met him, he's just such a decent guy. And he said, great choice, great people there. He said, hey, listen, before you go, I kind of gathered from your resume that you're from Alabama. Is that right? And I said, yeah. And he said, do you know my buddy Bill Pryor? And I was like, who was then the Attorney General of Alabama? And I said, no, I don't know him. And he was like, I think you ought to get to know him. Like, you just never know. Like, he's an Alabamian, you're an Alabamian, you might be swimming in the same waters. He might be able to help you someday. He said, you should just reach out to him, call him. And I said, boy, I don't know. Just cold calling the Attorney General of the sovereign state of Alabama, that seems like a weird thing to do.
Yeah.
And he said, no, he's a cool guy. He would think this is totally fine. And so I think I sent his assistant, an email and said, the general's friend, Jeff Sutton, says that I can call him. I hope that's okay. And so, got in touch with him, and he was like, oh yeah, listen, I'll be up in Washington, in a couple of months for whatever. And you want to try to grab breakfast together? And I said, yeah, that'd be great. So we had breakfast, and he said, listen, when he got there, he said, listen, I've just instituted this new office, the Office of Solicitor General. And he said, I've just hired the first person into that job. But I assume this will be something of a revolving door. And if this person ever shoves off, is that the kind of thing you'd be interested in? And I was just like, yeah, that would be great. And so I kind of put it out of my mind for maybe 18 months or something. And then one night, I'll never forget, I was up at the firm getting a brief ready for filing in the Third Circuit, and came down to my office from a conference room or whatever, and had like 3 voicemails and 2 emails from Bill Pryor saying, I need you to call me right now. And so I called him, and he said, Nate's leaving. Do you want the job? And I was just like, whoa, yeah, I need to talk to my wife, but I think I do. So I went home and talked to my wife, and ever the trooper, she said, if this is good for your career, let's do it.
What an amazing story.
Yeah, and it's crazy. But so, the point of all of this really is, like, had I not taken Jeff Sutton up on this little piece of advice to, like, reach out to Bill Pryor, my life would just be totally different. It wouldn't be a bad life, I'm sure. It'd be a great life. It'd just be a very different life, because I never would have been the SG, never would have moved back to Alabama, certainly wouldn't be on the 11th Circuit. So it's crazy.
You should send Sutton like some flowers every year or something. I mean, it's
listen, I have told him, how much I appreciate that nudge so many times. And really, I do hope it's something that law students will take to heart, because I always tell these kids, look, you're going to brush up against people who are, kind of fancy. And you might think you're going to have 2 instincts. One is, I'm not worthy. I don't belong in this person's sort of orbit. And so I'm just going to kind of shrink back. And the other is, holy cow, like I'm in this person's orbit. I ought to get to know this person, not from kind of a cheesy networking kind of way, but like just sort of develop a genuine relationship. And that person probably is just really decent, like Bill Pryor is, and really wants to help you, like he did, and is going to. And so, like, allow that to happen. Don't bid against yourself by not getting yourself out there.
So amazing. I have a similar story. You know, like I said, I was at the University of Miami Law School my first year, and I did well. And I sent an application off to Harvard Law School just on a whim at the end of my first year. And a week before school starts, back then we had beepers. If you remember. And so I was in like the law review training at UM. It was the Monday before class started, the following Monday, and I get some beep from a 617 area code. I had no idea what it was. So I go outside, I call, and it was the admissions officer at Harvard saying, "You've been accepted as a transfer student. You're one of 5 students. We need to know by 5 p.m. today whether you're going to come start next Monday." And so I called my dad. My dad was a lawyer here in Miami for 50 years. My plan was always go to UM and practice with my dad. And I called him and I said, "Listen, I'm just going to stick in Miami. I'm doing well. I have a girlfriend here. Things are going well." And he said, "Listen, leave the law review. Go pack up your apartment. We'll go to the airport in the morning. We'll buy a ticket and I'll go with you and we'll get set up in Cambridge." And it was this moment, like my life changed. I went to the law school there. I met my wife on the first day of school.
Wow.
Trajectory of my life changed in that one moment, similar to your Sutton story. It's wild how those sort of decisions in the moment make so much of a difference in your life.
That is so cool. I mean, and really it's funny because I have a similar story with the way I met my wife. I went to my freshman year of college, I went to Vanderbilt. And just didn't love it for reasons we don't need to get into. Didn't love it, so transferred to this school, like sort of back home at in Birmingham at Samford, and by so many accounts that was sort of like a strange choice. But that's where I met my wife, and so I always tell our 2 boys, "You'd better be glad that Dad didn't like Vanderbilt, because it's not as if you would exist in some other family. You just simply would not exist."
That's right.
The same for you. Like, what if you had stuck at Miami? Your children would not exist.
My whole life would be different. I mean, of course, my wife, my kids, my career, every like the whole, that one moment. And I give my dad a lot of credit because, he knew if I did this other thing, I probably would not end up in practice with him, right? I mean, I ended up clerking and then doing a whole bunch of different things that I wouldn't have done had I stayed. Probably wouldn't have done the same thing. So my whole life changed. It was a fascinating sort of moment.
It's crazy. I mean, things like that are the things that will send you down into like the multiverse rabbit hole.
That's right. Exactly. Maybe your kids exist in a different timeline.
That's right.
So then you argue a bunch of cases in the Supreme Court from Bill Pryor's office. I went back and listened to some of those arguments when you were a kid.
Boy.
It was great. I loved it. And, one thing that struck me is how different the court is now. There's only one justice the same, which is, it feels like yesterday that it was the Rehnquist court, right? Like it's wild to me that only one justice is the same. Oral arguments, of course, much different now than it was back then. Back then it was freewheeling. Thomas never spoke. Now it's, justice by justice. We hear from Thomas a lot. What do you think is a better format for oral argument? You like it back then better or now better?
Yeah, it's interesting. So I guess I have mixed feelings about it. On the one hand, I think, you're sort of in the same way that at least I still listen to the same music I listened to in high school and college. Like I'm sort of a throwback kind of guy, I suppose. And so I sort of think the way I came up is the right way. I was having this debate with someone the other day about whether the 80s objectively, was the best decade, which I'll go to my grave believing that it was, obviously.
Yes, of course.
But so in some respects, I guess I think the old way was better, in part because the new way just leads to like 4-hour arguments. That's a lot to take in. As now a consumer of them, if I sit down and think, I want to listen to this one, so I've got a case up at the Supreme Court right now, that one of these social media platform cases, the net choice, one of the 2 net choice cases. And so I wanted to listen to the net choice cases, and there's there are parallel cases, one from Florida, one from Texas. And so I tuned in for the Florida one, And frankly, after like 3 hours, I was so exhausted that I was like, I can't possibly listen to the Texas one now.
Right.
So
But it's
um,
interesting, right, Judge, that the Supreme Court now has longer arguments. Other countries in the Supreme Court, when there's an argument, sometimes they go all day. Our appellate arguments, like an argument before you all, is 15 minutes aside. To me, way too short. Like I always leave the argument thinking, oh my God, like I barely scratched the surface of argument heading 1. Like I didn't get to 2, 3, and 4.
yeah.
15 minutes strikes me as too short.
So I tend to agree with you about that. And what I was going to say, one of the other side of the sword about the new format is that a lot more people get involved, and you get the sense that all the questions get vetted. I mean, basically, like as Chief Justice Roberts is going down the line, like you get to keep going until you've asked all the questions you care to ask, which is great. And by virtue of that, the lawyers, by and large, get to say they have at least have time to say everything they want to have said. And I tend to agree with you that is a real positive of this turn. And I'm kind of a pro oral argument guy. Different judges have different attitudes about it. Ideally, of course, we'd argue every case. Now that's simply in our court not physically feasible, but I think not only are oral arguments fun, both for should be fun for the lawyers, but I think they're fun for me. But I really learn a lot at the oral arguments.
So I wanted to ask you about that because, some judges really say the cases are all decided on the papers. By the time oral argument rolls around, in the vast majority of cases, it's been decided. I mean, do you think oral argument makes a difference? Have you gone into an oral argument and had your mind changed by advocacy in an oral argument?
Yeah, for sure. So I do agree with like the baseline proposition that in appellate advocacy, your best chance to make your best case is in your paper, is in your brief. No doubt about that. Just because, oral arguments they're still kind of sort of hurly-burly-ish, and you're just not going to be, that there are very few people, I think, who are 110% of their best self when the lights are really bright and the pressure is on. There are very few Paul Clements, for instance. So we've had Paul Clement argue before us a few times, and he's like, I have to believe he's better in the moment than he is in the moods. Very few people, I think, are better in the moment than they are, sort of in the bathroom mirror or in, sort of around the conference room table. He's just better. But very few people are. And so I think you do need to put your best foot forward in your brief. And so much of the advocacy is done in the brief, and a lot of thinking is done in advance of the oral argument. So I agree with all of that. But, in a given week, we're probably hearing between say 15 and 19 cases or something. That's a lot, frankly, to get your head around. And so the idea that I could have, say 15 cases fully locked down, sort of hermetically sealed off, nothing can change my mind. That just seems inconceivable to me. I'm just not that smart. And so I think typically at oral argument, I'd say the cake is about 85% baked, but I think it's not even a rare occurrence that something happens at the OA, either something the lawyer says in response to a question, or oftentimes something one of my colleagues says.
Right.
And I just think about sometimes you just think, damn, I hadn't thought about it from that perspective. That's different. I need to kind of reassess a little bit.
And so, a lot of young lawyers, law students listen to this. What advice do you give to young lawyers for oral argument? I mean, it's one of the most stressful things a lawyer can do, as as a young lawyer who argued lots of appellate cases. So what advice now that you're a judge do you give to young lawyers?
Yeah, I think the best piece of advice I could give, I guess a few. Number one is remember that the judges who are there for that week, if we're talking about, say, the U.S. Court of Appeals, for instance,
Yep.
If we're in Miami hearing cases for a week, we have, 15, 16, 17 cases, you only have one. In all likelihood, you only have one. And so you ought to know the case a lot better than I do. Like I'm scrambling to catch up to you, but I'm also scrambling to catch up to, 16 other cases. And so you ought to know the case better than I do. And so I think that young lawyers, when they walk in, that should give them confidence. Like if they have prepared properly, then they really ought to feel like they're in charge of this proceeding. I mean, the judges are sort of coordinating it, but substantively, the lawyer ought to be in charge. He or she ought to know more than the judges. And that ought to give young lawyers a lot of confidence, I think.
It's great.
Not that you can sort of like talk down to the court or whatever, but you can and should like direct the court. And, if the judge says something stupid, as I'm sure I've said 1,000 stupid things in OAs, you should say, respectfully, I disagree. And here's why. And so I think that should give young lawyers a lot of confidence. And then I would say, just from a prep standpoint, I think, and I fell into this trap as a young lawyer. You can, I think, fall into the trap of thinking, I just need to survive this thing.
Right.
I just need to survive it, like, without embarrassing myself. And I think that's a real missed opportunity, because there was almost never a time, and I'd be curious to hear what you have to say about this, but there was almost never a time in prep for an oral argument that the case didn't kind of like crystallize for me in a new way. I always thought truly that briefing would be better if you could moot court arguments before you wrote your briefs. Then your briefs would be both better and shorter.
So funny that you say that. I totally agree, because by the time you get to oral argument and you've done the moot, you're like, man, why did I write it that way?
Exactly.
Maybe I shouldn't have included that argument. That argument's not going to go anywhere, right? Like you see the flaws when you do the moots in your brief writing.
Exactly. And so, one thing I think that, young lawyers especially should do as they sort of ramp up to the OA is not to be afraid of that sort of like epiphany moment when the case synthesizes or crystallizes for you in a new way. They're typically, and as you were saying, you're only going to you have a very short window of time. Right. And so I think you need to figure out like what I've heard it described as the kernel of the case, like the one thing that drives you sort of a result in your favor, a home base that sort of animates and motivates your argument, and like drill that. And then be prepared, of course, to answer the cats and dogs questions that the judges have, but try to come back to your home base when you can.
I think that's great advice. Let's switch gears for a moment and talk about legal writing, because I know you're a legal writing guru, and there's so many great writers on the 11th Circuit, right? Like there's you, Judge Rosenbaum, Judge Carnes, Judge Pryor. I mean, tons of great writing that people are talking about. I love your unique style because it's so informal. That's the style I love. But as an advocate, it's different than as a judge, right? Like you have freedom to be you and write the way you want to write. I still write informally as an advocate, but sometimes people don't like that. They say, you can upset judges. So let me start there. I mean, were you an informal writer as an advocate too, or has that just sort of become your way as a judge?
Yeah, it's a great question. So the honest truth, David, is that I never aspired. People ask me about it all the time, better or worse. I guess some people like it. I'm glad you like it. I'm sure some people hate it, but for better or worse, this is just sort of how I communicate. It's not like I thought, oh, I'm going to be an informal writer, a conversational writer. This is just sort of how I do it. And I think that, another piece of advice that I would give young lawyers is find your own authentic voice and be that person. You shouldn't aspire to write. I tell my law clerks, don't try to write like me. Just write, give me the substance. And it's going to come out sounding like me because I'm very involved, of course, in the drafting and editing process. So don't worry about trying to mimic my voice. Find your own voice. And I think authenticity is really important. I've got friends, for instance, you may remember from our law school days, Canon Shanmugam, who was a year behind us. He and I have been good friends for a long time. And I used to tease him when he was in the SG's office, the big SG's office in Washington. I used to tease him that I could get away with things as an advocate that he could never dream of. But I think the truth is Canon's voice, and he's a brilliant lawyer, Canon's voice is just a little bit more formal, right? And so he ought to just lean into that.
And he's more formal. He's more formal in oral argument too than if you see a flat in oral argument, totally different styles.
Totally. So yeah, I just think that people ought to find their own authentic voice and lean into that. And now for people like you and me who do write more informally or conversationally, I do think that we are at risk of crossing some line. And so I think you have to constantly police yourself. And I mean, the honest truth is, since I've been a judge, I think there are probably a couple of times that I've gotten a little too cute. And those are, I sort of regret those extravagances and try to do better the next time. But I don't want to like forsake my natural voice just because of that risk. I just want to police the risk a little bit more carefully. I guess, maybe the risk at the other end of the spectrum is some sentence that says, like, now here comes your humble petitioner, or whatever the legalese BS would be.
Yeah.
But, I think authenticity is really the key, to be honest with you. And that's true as well in oral argument.
I totally agree about both. And the advice I always give young lawyers, both for trial and appeals, by the way, is you have to be you. Like, you can't try to be someone else in trial. I remember when I was a young lawyer and I saw Albert Krieger. I don't know if you know Albert, but he was, he was one of the great trial lawyers with this booming voice. And, nobody could mimic it and nobody could copy it. And if you tried, you would fail. You could not be Albert. Only Albert could be Albert. And so you just have to be you.
Yeah. I always tell people that if I try to act smarter or fancier than I am, I'll just be exposed as a fraud. So like, why try? I mean, I basically like made peace with the fact that I'm smart enough and I work really hard, and like the writing really matters to me. And so I'm just going to try to do the best that I can.
All right, you called me out on the country lawyer thing. I'm going to call you out on that too. So let's talk about, something that I know you've discussed a bunch and a lot of people have discussed, concurring with your own opinions.
Oh yeah, yeah.
This is, a Newsom special. So first, what's that all about, Judge? What's concurring with your own opinion about?
Yeah, it's a good question. So I'm not shy about concurring, and I'm not shy about concurring in my own opinion when necessary. And here's what's kind of behind that, is that I have a pretty firm sense of what the opinion of the court should do and should not aspire to do, right? I really think that we ought to decide sort of discrete cases and controversies relatively minimally, sort of decide the issues presented. I'm not a fan of alternative holdings. There are, different judges have different views about these. I guess somewhat ironically have written a concurring opinion criticizing alternative holdings.
Yes.
But so I think it's because I have a pretty firm sense of what the court's opinion, the judgment bearing opinion of the court ought to do. And that's a pretty narrow sense for what that ought to do. Combine that with a sense that I have some obligation to like advance the discussion of the law.
So who's the audience then for the concurrence? Let me interrupt you. Who's the audience? Yeah.
I mean, I think so, typically I think the audience in the majority opinion, first and foremost, is the parties.
Of course.
Here's why you won or you lost. And, sort of with, sort of understanding and empathy, I think I once heard Amy Barrett say that you should write the opinion of the court so that the losing party sort of understands why he or she lost. That seems exactly right to me. And so I think the audience for the concurring opinions, where you say, this doesn't belong in the majority opinion because it is somewhat of an aside. It's like adjacent to this case. But I think, sort of the doctrine is off track, or there's a new way to think about this. The audience there, I think, really is, sort of other Court of Appeals judges, the Supreme Court, the Academy, whoever it is. I'm just looking for like ferment, right? Basically, if like, here's a different way of thinking about this that I think would improve the doctrine, which is confused. I'm happy for anybody who is sort of engaged in that same sort of like collective endeavor to listen, to sort of read and react. And frankly, it doesn't even much matter to me if the reaction is like endorsement or mockery or whatever, so long as it's just sort of like a marketplace of ideas kind of thing. I like genuinely believe in the power of ideas. So I think I have some obligation, if I feel like I've done the work, to like share it for what it's worth. And it might be worth nothing. but for whatever it's worth, to put it out there so that people can react to it.
And it looks like you're rubbing off on your colleagues a little bit, because I read this Burnett case, and it wasn't just you who concurred in your own opinion. It was the whole panel concurred. You, Jordan, and Rosenbaum concurred with the opinion, which I thought was hysterical.
Yeah, it's interesting. I think I've been involved in 2 cases now where there was a unanimous opinion and then, in effect, a unanimous concurrence.
Yeah.
And sometimes people will ask me, like, why isn't the concurrence then likewise the judgment of the court? And I think it's this notion that there are some things necessary to the resolution of the case. That's the opinion of the court, the judgment of the court. And then if all 3 of you have if you agree in some aside, that's fine, but it's still not necessary to the resolution of the case, and so doesn't belong in the opinion of the court.
So you probably don't know this about the Burnett case, but I represented Andrew Gillum, who was charged in Tallahassee with the same investigation and the same agents. And there was a lot of litigation in that case about what we would be able to cross the agents on. And this issue came up in Burnett because Burnett, the undercover agents, took the snitch to Vegas and paid for him to have sex, and then they lied to the prosecutors about it when it gets uncovered, and the judge kept it out, and on appeal, you all find harmless error on that issue. But the case had not been decided until about a week before our Gillum trial, and so we were litigating. Right. So we were litigating whether we could do this or not. And we listened to the oral argument, and we thought, wow, you guys really had a lot of tough questions for the government about this issue. So we were trying to convince the judge in Tallahassee, look, it's going to come out our way. We should be able to. And then, of course, he smiled when the opinion came out about a week beforehand about this issue. So that impacted our trial in Gillum quite a bit. Although, it's funny because we were talking about, well, it was harmless error. Mm-hmm. So if you do harmless error again, like, is it still harmless a second time around?
Yeah, it's interesting. So I've forgotten so many of the details of that case, but I guess I'm wondering if the basis for our decision was harmless error, I would think that would be colored by the record in our case. Like, right. If the record in your case was different, did you have an argument that, well, yeah, it might have been harmless on that record, but it's not harmless on my record?
Yeah, I mean, our case was a little worse because the snitch wasn't a snitch in our case. So we wanted to really bring out the fact that they lied to prosecutors initially when confronted with this. And so the government had, a better argument that it was a little more tangential than it was in Burnett. So it stayed out, but in the end, it didn't matter, Judge. We got an acquittal. So it was
okay. There you go.
It's not going to be back before you, that issue, a harmless issue. Another one that I really liked was the Campbell concurrence.
Yeah.
And the issue there was, should appellate courts be deciding issues not raised by the parties? And this is an issue that's always sort of fascinated me, like what the role of both district judges and appellate judges are. And it comes up from time to time, both, of course, the way it came up with you all, which is one party didn't raise the issue, but it comes up in district courts too. Like, if the parties agree on a sentence, should the judge come in and say, you know what, I don't agree with that? That is that properly before a district judge? I got in trouble with the Michael Flynn case because I wrote a bunch of op-eds saying, that was a case that the executive branch wanted to dismiss, and the judge said, well, hold on a second, I get to inquire about the executive branch's decision to dismiss. And I was always wondering, well, why should that be if the party charged with prosecuting is dismissing and the defense says, no, go for it? Why should a judge be able to step in there? So I think the Campbell concurrence is fascinating. Yeah,
Campbell was an interesting case, and Campbell was actually, so that's before us in bank, or as I say it in bank. All the sophisticates say en banc. I call it because I'm from Alabama. But yeah, so that's before the full court, and that was, so that was a dissent that Judge Jordan and I jointly wrote. And what, one thing that I'm particularly sort of proud of about that opinion is that I think it sort of gives the lie to the idea that we're all just a bunch of reds and blues and R's and D's. That's a case where sort of the way the votes shook out, it was me. I say it was like me and the libs, so to speak, right? Dissenting, losing to be sure, but there was a principle at issue in that case that mattered to me in terms of like, and it sort of goes back to the conversation that you and I were having about sort of whether courts, sort of what should go in opinions of courts. I just have this like pretty modest sense of the judicial power. And like in a case like that, where the government, I think, had not just forfeited an issue, but I think had like affirmatively, intentionally waived the application of the good faith exception to the exclusionary rule. Then when the government makes a decision to walk away from that, it seemed to me that a court shouldn't itself resurrect it and inject it back into the case on the government's behalf, shouldn't become an advocate for the government. I mean, for any litigant, let alone the United States government, sort of very well-heeled, well-resourced, good lawyers. They know exactly what they're doing.
And they would jump on us if we waived it, right? I mean, that would be the first thing out of their mouth.
Yeah. And so, but one thing that's important to me when I go around the country giving talks, it's really important to me that law students, lawyers, observers believe, as I do, that judges are actually trying to do the law.
Mm-hmm.
And I think to a certain extent the proof's in the pudding. And I just, I hope, what I tell people all the time is, if you say like you've got a theory of law, whatever it is, and occasionally that theory doesn't put you in conflict with your sort of political priors or preferences or whatever, if you don't have that pinch, sort of not occasionally, but more than occasionally, then you must be doing it wrong. Because there's simply no reason to think, for instance, that formalism, whether sort of manifested in originalism or textualism, whatever the ism of the day is, that sort of ought to map on to political conservatism. I just don't believe that.
Well, that's what I really loved about Justice Scalia, is he ruled for the defense probably more than anybody, because he was he just read the words, and if it led to a reversal, and he joked about it, he was the most criminal defense friendly justice on that court, I think, which most people would never have guessed. Yeah.
And I just think, that is what, to me, makes the law kind of a magical thing. I don't think, I just don't find politics that interesting, and especially today. But I've never really found politics that interesting. What fascinates me about the law is trying to solve the puzzle, and the puzzle doesn't have anything to do with the politics of the situation. It just, to me, it's sort of largely internal to the law itself. And that's what I love about being a judge, is trying to solve the puzzle. And if the puzzle comes out one way, fine. If it comes out the other way, fine. I do not care how it comes out.
Well, then let me take you on a little bit, Judge, on this idea that, appellate judges on the intermediate level should be, modest and cautious. I've seen some of your other talks where you talk about, the Supreme Court, you have to wait till the Supreme Court, your bosses decide. In fact, you talk about that in the Burnett case, right? You say in the concurrence, listen, they decided McDonnell, but, we're not prepared to reverse Burnett. We have to wait until we're told by the bosses. But why? The Supreme Court keeps reversing these going too far prosecutors, McDonnell, all these other cases, Bridgegate, where district judges and appellate judges have affirmed and sort of allowed these prosecutions. I mean, the Supreme Court takes so few cases. To me, the only way to sort of advance the ball is to hold prosecutors feet to the fire and say, you know what, this is too far. And then they can always go up to the Supremes, but it's so hard for a criminal defendant to get heard unless you're the governor of Virginia or some other big case. So to me, I think appellate judges and district judges should be doing more of checking government power and then seeing where that leads.
Yeah, I guess, and I don't really think you and I are saying fundamentally different things. And I hope anyway that, people would look at my record and they would say this guy's either dissented in sort of criminal defendants' favors or has written opinions in criminal defendants' favor more often than anybody would have expected. But I guess I think it's not the court, either a district judge's role or a court of appeals role to like thwart government power. I just think it's the role to like do the law as it exists in front of you, and not necessarily to anticipate where the Supreme Court might be headed or to steer the law in any direction. I know this sounds sort of simplistic, so I won't say sort of balls and strikes, but it's to try to just like decide the case that's in front of you based on the law that applies, and then let the chips fall where they may.
One of the arguments that we hear a lot from prosecutors is one I think you hate, which is, this is the way it's been done. This is the tradition of this statute, which to me sounds like an argument that at least Judge Newsom isn't going to be buying.
Yeah, so I agree. I don't love sort of resort to tradition sort of in the ether, like especially sort of because it has been done this way for the last few generations. That's how it ought to be done now.
Right.
So I guess I just believe, and if I didn't, I don't think I'd want to be a judge, that there are typically in cases, there aren't always perfectly right and perfectly wrong answers, but there are usually, almost always, objectively better and objectively worse answers, and that you can come to those by reference to sort of existing legal materials without sort of pushing the envelope as the judge.
So I'll talk to you about one more substantive area, and then we can sort of end on some fun stuff. But
yeah.
The other really, to me, interesting concurrence was the one about and meaning and whether and means and or and means or. And to me, the lineup of judges in the 11th Circuit was fascinating there too. And it seems so obvious to me that and means and if Congress wants to fix that, Congress can fix it. But the Supreme Court came out the other way, which I was really surprised about. And Gorsuch wrote this dissent, and he's sort of getting his Scalia voice, I think, on the high court.
I agree.
To me, and I've talked to the Chief Judge Pryor about this as well. I like to tease him that there's more en bancs now. There's more en bancs for defense now. Because I used to give him a hard time about that. But this is a good example of the lineup being all weird and sort of holding the words to what they mean.
Yeah, I totally agree. And I think lineups like that should restore people's faith in the fact that judges are judging and not politicking. I think it's pretty. I don't remember exactly what the lineup was, but I remember that the Chief and I were sort of voting with the criminal defendant. I think some of my Trump-appointed colleagues were on the other side. So, it's when you've got sort of Republican-appointed and Democratic-appointed judges sort of all over the place. This is true in the Supreme Court as well. I try to, when I'm teaching classes, I try to make people understand that, there are going to be some cases that break down along ideological lines, but man, are there a lot of interesting cases, meaty, important, thorny cases that don't. And those are the ones I think let's pay attention to those at least as well as the others. But yeah, so I agree, and this is sort of part of my let the chips fall where they may kind of attitude about this is that Congress has written a goofy statute. I take the point that from 30,000 feet. Maybe this doesn't make all that much sense. I mean, like the Chief, who's a legitimate expert in sentencing policy from having been on the sentencing commission for so long, I think he's got a pretty good argument that this is not nonsensical. It might not be the most logical sort of reading from a common sense perspective, but it's not crazy. But even if it is close to crazy, I just don't really think it's the court's job to massage things to make it work. I think Congress has a job to do, and it ought to have, to use your phrase earlier in talking about prosecutors, it ought to have its feet held to the fire. And if you didn't legislate properly this time, it's not our job to fix that. We're going to enforce the law that you've given us. And then if you think it's goofy, then fix it. Separation of powers is a real thing. Yeah.
So Judge, I heard recently that you went through a health scare, and I don't know if you're okay to talk about that, but to me, it's wild what happened, and that your clerks were able to help you out.
Yeah, it's nuts. I've always been very healthy, so far as I know, and about I guess, I don't know, 5 or 6 months ago now. I was in the gym. I go to the gym every morning before I come to work. And I was in the gym one morning and I started feeling like a little lightheaded. And the only way I know how to describe it is a little confused. And I found myself in the gym just sort of down on all fours, just kind of having to shake the cobwebs off. And once that sort of episode passed, like an idiot, I got back up and thought, well, I feel fine now. So I finished my workout and, went for a run and, came
Probably
back.
wanted to kill you when she heard that story.
Yeah, right, exactly. So then, I came up to my office, showered up, got about halfway dressed and woke up in my bathroom floor and thought, oh, that's not good. And I thought, at that point, I thought, yeah, I guess I'll give the doctor a call. I thought what was happening is maybe I was having like these little mini strokes or something. And so, but I felt okay at that point. So I wandered down the hall to talk to a couple of my clerks who happily that day had come in early. And as I was talking to them, I felt that same kind of confusion coming on. Next thing I know, I'm passed out cold, and one of them is on top of me, sort of shaking me sort of back to life. Long story short, really, is that I knew I had a very low resting heart rate. Like I sort of lived in the low 40s. And that combined with some kind of, sort of glitch in the firing of the electrical activity in the heart, just caused my heart occasionally to go like way too low. Or, I think in the hospital I once had, there was a 12-second pause between heartbeats. That's just like too long.
Yeah.
And so in any event, long story short, they gave me a pacemaker. And so I've had a pacemaker for 5 months and I feel totally fine. And it basically just prevents my heart from ever beating more slowly than 50 beats a minute.
And are you working out in the courthouse again?
Yeah, back to working out. And I mean, I feel totally fine. Heart-wise, I don't feel any different than I did before. And It's just like, it's totally amazing. Like, what a time to be alive when doctors can say like, oh, I don't know, a generation ago, 50 years ago, you just would have been dead on the floor of your bathroom. And instead, we've got this little microchip that we can implant in your pectoral muscle that will run your heart. That's unbelievable.
Unbelievable. And now your clerks have the greatest all-time story for the rest of their career.
Exactly. And it's funny. They really sort of rankle because the story, as I tell it, it keeps getting better and better and better. That they're, one of my clerks keeps saying like, Judge, you've got to quit telling people that I saved your life. But I tell both of the two who were in that morning, look, the honest truth is we just don't know what would have happened if you weren't here.
Right.
And so I choose to believe that they saved my life. And I truly I want them to remember that. That's like a big deal.
That's a pretty cool story. So, speaking of clerks, like you hire your clerks when they're like out of the womb. Like what's going on? I mean, what's going on, Judge? I mean, you don't even know what they're doing in law school and you're already hiring clerks.
I know. It's not something I'm particularly proud of. It's just, it's sort of like, is what it is. I hate to say that, but basically it's kind of a race to the bottom, I guess, but the judges with whom I am competing for the pool of talent likewise are hiring early. And so, I don't think any of us love it, but there's this just sort of huge collective action problem that, we all sort of do it. So yeah, I mean, I'm hiring a lot of kids in the first year of law school.
When the culture when we were in law school was, you'd clerk right after law school, either on the district bench or on the appellate court. When you do the Supreme Court, you got to wait a little bit, but the culture I think has changed, right? Like now, do people get jobs out of law school first before they clerk, or are they coming right out of law school and clerking again?
Yeah, some of both. It's much more a mixed bag than it used to be. Like, so for instance, now I have most of my clerks, I guess, are fresh out of law school. But one is out of law school and a joint PhD program. That's a little different. And then one of mine was sort of not mid-career, but mid-associateship at Covington and Burlington, DC, and came to clerk for me for a year and then is headed back. So it's a bit more of a mixed bag. And as I'm sure you know, one thing we see a lot more than we used to is kids doing multiple lower court clerkships, either district circuit or sometimes circuit. I've seen a lot of that. And that's just a very different sort of phenomenon than it was when you and I were coming up.
It really is. This is sort of like oral argument. We have about an hour. I wish I had 4 hours because there's 20 topics that I didn't get to. But let's end with the fun one. And I like to ask judges about this. Like, what do you do in your free time? We heard about working out, but what hobbies, what does Kevin Newsom do in his free time?
So you'll appreciate this as the father, you said, of three, right? So
Yep.
as the father of two boys, the second of whom is about to leave the house. The honest truth is, as a parent, I basically, what would the past tense of forsake be? I forsook. Forsook my hobbies.
I'll look it up after.
Yeah, I didn't think there was time enough in the day really to try to be the kind of husband and father I wanted to try to be, and to be the professional I was aspiring to be, and to have time-consuming hobbies. I just couldn't figure out how to do all of that. And so I tried as best I could to make my hobby, like my really intensive hobby, to be like a decent family man, and to, be a good dad who was at the stuff and, went to the games or whatever. So, now I'm going to have to like try to find some. My wife and I are like, what are we going to do? Sort of empty nesters. We're about to be empty nesters. It's crazy.
You're going to have some time. You could be a podcaster if you want. So, that's the thing with like my hobby has always been sort of the law. Like I love what I do. So it's always interesting to me when I talk to people who like, doing these other things. It seems like you're the same way. Like you love what you do. And so in a lot of ways, like your job is not really a job. It's your hobby too.
Yeah, I really do love it. I feel so lucky to be doing what I'm doing, as I know you do as well. And like the honest truth is, like before my wife and I had children, like did I play golf recreationally? I did. And then like we had kids, and I was like, I'm not spending 5 hours on a Saturday on the golf course. No way. Like I'd just way rather be with my kids.
Yeah.
And so I just couldn't find much room, at least for time-consuming hobbies, if I was trying to be like a really good lawyer or judge and at least a passable, sort of husband, father. And so, I don't know what I'll do now. The only sort of me time I ever really sort of like carve out for myself is the morning, where I go to the gym, work out, and listen either to like podcasts or books. My kids give me sort of just unmitigated hell about this, because they don't see how you could possibly work out to a book or a podcast. You need like sort of like really ragey rap music or something, or thrash metal to work out. But it's the only time I have to listen to books or podcasts. So I've got to kind of multitask in the gym. So that's what I do.
I love it. All right, let's end on one last thing. We need a good Judge Pryor story. Any good Chief Judge Pryor stories?
Yes, I have a great Chief Judge Pryor story. So he and I have been friends for so long, and before I was a judge, my kids were probably, let me think about this, I can date it. So it was 11 years ago. So my kids would have been 10 and 7, something like that. So Bill is a big Alabama football fan. I am an Alabama football fan, but he is
He's a fanatic.
He's a fanatic. He is a fanatic. And so he asked me and my boys if we wanted to go to the Iron Bowl, which is the annual game between Alabama and Auburn. It was at Jordan Hare down in Auburn. And so we made the trip down with him. We had tickets 2 and 2. I was sitting with my younger son, and Bill was sitting with my older son in a different part of the stadium. And this was the infamous kick six year, where Alabama, time expiring, tries a 57-yard field goal, comes up short. Auburn fields it, runs it back to end regulation and for a walk-off win to ruin Alabama's theretofore undefeated season. And so we, so my older son, who was sitting with Bill, it says that when Chris Davis, Auburn's player, who's running the ball back toward the end zone that Bill and my son MJ are sitting in, MJ said that Bill turned to him when Chris Davis got to about the 30-yard line and said, "Let's go." So they begin to exit the stadium. We begin to, my younger son Chapman and I begin to exit the stadium. We meet up outside. Silence. No one saying a word. And it's clear from Bill's countenance that no one should say a word, right? So we proceed back to the car. I'm driving. We get in the car. We get all the way out to the interstate. I mean, like half an hour has passed at this point, and still no one has said anything. And so finally, I decide that there's like a teachable moment here for my kids. And so I say, you know what, boys, that was a tough way to lose a football game. Like that sucked. Sorry, and I'm sorry about that. But that may go down as the most famous play in college football history, like right up there with Stanford, Cal, like, and I said, and you were there to witness it in person, and that's pretty cool. And Bill, to hear my son MJ tells the story the best. He says that Bill Pryor looked at me like I had a third eye and said, "What are you talking about? There is no silver lining here. There is no teachable moment here. Like essentially, like go back to being silent."
That's great. What a great story. That's a great place to end. Judge, thank you so much for doing this.
Oh, this was so great and so fun to catch up with you, David.
That was really cool, wasn't it? I hope you enjoyed hearing from Judge Newsom as much as I did. It was so much fun to speak with him and to talk about all these topics. And I just want to thank Judge Newsom for spending so much time with us and being so accessible. It's really great that these judges are doing this. We learn a lot and we really appreciate it. So thank you, Judge Newsom, and thank you all for listening. Please keep sending your comments about other potential guests. I really enjoy hearing from you. So thank you again, Judge Newsom, and thank you to the listeners.